A teenage girl reports an attack. What comes back is paperwork, procedure, and a sentence people can barely believe. In another country, a child is hurt, and the punishment feels smaller than the damage. Then a dangerous man walks free. Maybe one case is failure, but after enough cases, people start seeing the system. Epping did not become angry because of one loud headline, but because the details made the official answer feel smaller than the case itself. Hadush Gerberaslazy Kabatu was convicted after sexual attacks involving a 4-year-old girl and a woman. And before anyone turned it into politics, people were already asking what kind of protection the authorities were really offering. The sentence came down as 12 months, and outside that courtroom, the number did not sound like justice taking a serious case seriously. A lawyer could explain the guideline, a judge could point to the category, and someone in government could talk about process. But normal people heard a teenage girl, another woman, a conviction, and 1 year. That is where trust starts to crack, because people do not live inside legal language when they are trying to understand whether the streets around them are safe. After prison, Kabatu was supposed to move into immigration detention, with deportation as the next step. So this was not some unclear moment where nobody knew what should happen. The plan already existed, the direction was clear, and somebody only had to make sure the man at the center of that case stayed under control until the process was finished. Instead, he was released by mistake, which is the kind of phrase that makes a serious failure sound like a small office problem. He was not cleared by new evidence, he did not win an appeal that changed the whole case, and the conviction did not suddenly disappear. He was simply let out when he should not have been let out. For ordinary people, that is hard to accept, because the same state rarely looks confused when the mistake belongs to them. Miss a payment, park in the wrong place, or send one form too late. And suddenly, every rule becomes sharp, every deadline matters, and every letter finds the right address. Yet in a case where control mattered most, the authorities became careless at the exact point where they had to be strict. Kabatu was later found, taken back into custody, and deported, but that did not erase what people had already seen. A serious case, a sentence many could not understand, and then a release that seemed to help the wrong person first. That is why Epping did not feel like one mistake. It felt like a warning. Vienna is the case where the sentence itself became hard to hear, because after what happened to a 6-year-old child, 4.5 years does not sound like a punishment that understands the damage. A 2-year-old man was sentenced after the girl was raped in his apartment, and the same case also involved serious abuse of a minor and child abuse material. When that number came out, a lot of people did not need a long legal explanation, because the first reaction was simple and human. How can something that serious end with a sentence that small? Maybe Austrian law had a path to that result, with rules, limits, admissions, evidence, and all the language courts use when they speak inside their own world. Outside that room, the sentence landed differently, because nobody hears about a 6-year-old child and then calmly accepts a few years as if the damage can be boxed up and counted. Her family does not get a clean ending because the verdict is final, and the child does not get her life handed back because adults are finished with the legal part. 4.5 years can pass on a prison calendar, but the harm from a crime like this can stay in a home, in a body, in a childhood, and in a family long after the file is closed. That is why this case made people so angry, because the punishment did not feel like it stood beside the crime. People were not asking for some wild mob version of justice, and they were not asking the court to throw away every rule because the public was upset. The question was much colder than that. If the law can look at a child, look at what was done, and still land there, then maybe the problem is not only one sentence. By the time the court called the case finished, many people had already seen something they could not unsee. Vienna showed a child hurt, a man sentenced to a few years, and a justice system that sounded calmer than the crime ever deserved. No court can undo the damage, but the punishment should at least prove that the damage was understood. Gera was different because the case did not begin with a quiet court file, but with a video of a 4-year-old old boy being attacked while others stood around and filmed it. That detail matters because the phone turned the violence into something larger than the attack itself, since the victim had to deal with what happened in the moment and then with the humiliation being shared afterward. Police spoke about children and teenagers from different backgrounds, and German reports described more than 20 suspects between 12 and 15 years old. For anyone watching from the outside, the age of the group made the case harder, not easier, because the people involved were young enough for the law to treat them carefully, but the violence on the video did not look innocent. This was not two kids losing control for a few seconds and then walking away ashamed. It looked organized enough, public enough, and confident enough to make people ask where a child even learns to attack someone while another person records it. Then the legal problem came into focus, because in Germany, a child under 14 cannot be charged as a criminal defendant. There is a reason for that rule, since children are not adults, and the law cannot treat a 1-2-year-old exactly the same way it treats a grown man. The problem is what happens in the space between those two truths. When someone is too young for criminal punishment, but old enough to join a group, attack, understand fear, understand shame, and understand that a video can hurt the victim again. That is the gap people saw in Gera. A boy was attacked, the recording existed, suspects were known, and yet the strongest response for some of them could only move through youth services, family courts, school measures, and procedures that look invisible to everyone outside the system. For the victim and his parents, that can feel almost impossible to accept because they are not watching an abstract debate about age limits. They are looking at a teenager who was surrounded, hurt, recorded, and then asked to trust that some slow process behind closed doors will somehow balance what happened. If the law cannot punish every child involved, then the answer still has to be strong enough for the victim to believe that his pain was taken seriously. Because when violence is filmed, shared, and then explained away through procedure, the lesson can land on the wrong side. Joseph McCann is the case that makes the whole argument harder to dismiss, because he was not part of the migrant story, and nobody can honestly use him to blame people from another country. He was already known to the justice system, already had a history that should have made every warning light flash, and still, he was outside long enough to hurt more people. That is why this case matters here, because it strips away the easy political excuse and leaves the same ugly question sitting on the table. What happens when the authorities already know a man is dangerous, but still fail to act before the damage spreads? McCann had been released from prison, and the people responsible for watching him were supposed to understand the risk that came with a man like that being back outside. The public was not asking for magic, and nobody expects the police or probation services to predict every crime before it happens. But this was not some unknown stranger appearing from nowhere, with no past, no warning signs, and no reason for anyone to look twice. He was a man the state had already dealt with, already processed, already placed inside its own files. And somehow, that still was not enough to keep him from reaching new victims. After his release, he carried out a series of attacks against women and children. And only after that did the system finally become serious in the way it should have been serious earlier. Life sentences came later. Apologies came later. Reviews came later. The words lessons learned came later, like they always do, after ordinary people have already paid the price for somebody else's failure. That is the part people cannot get past, because justice that wakes up after the crime is not the same as protection before it. McCann proves this is not only about immigration, courts in one country, or one bad prison release in one town. It is about a pattern where dangerous people are known, warnings exist, procedures are written down, and still, the final result lands on the victim. The state can be sharp when it wants to chase a fine, enforce a deadline, or punish a small mistake from an ordinary person. Yet, when the risk is a man who has already shown what he is capable of, the same state suddenly becomes slow, divided, and full of explanations. By the time McCann was locked away for good, the public was not watching justice win. They were watching damage control arrive too late. After all of this, the hardest question is not whether someone sat in an office and planned every failure. because reality is usually messier than that, and excuses are always easy to find once the damage is already done. What stays with people is something colder. In Epping, a man is convicted after attacks on a 4-year-old girl and a woman. The sentence comes back as 12 months, and then the same system that already looked weak manages to release him by mistake when he should have been held. In Vienna, a 6-year-old child is raped. The court gives 4.5 years, and the public is left staring at a number that feels smaller than the harm it is supposed to answer. In Gera, a boy is attacked and filmed, while the discussion quickly moves toward age limits and procedure, even though the victim is still the one carrying the humiliation. Then, McCann strips away the last easy excuse, because he was not part of any migration argument at all. And still, the same pattern appeared around a dangerous man the authorities already knew. That is why people lose faith. They keep hearing words like safety, dignity, justice, protection, and lessons learned. But the real cases never sound as clean as the speeches. An ordinary person makes a small mistake, and the state suddenly knows exactly how to behave. A payment is missed, a deadline is crossed, a form is filled in the wrong way, and the answer comes back fast, cold, and without much patience. Yet when the case is serious, when the victim is a child, a woman, or a teenager, left with damage that does not disappear, the language changes, and the institutions start speaking in softer tones about context, rules, limits, and process. Maybe that is not a conspiracy. Maybe it is fear, weak law, political cowardice, or a system that has become more comfortable explaining failure than preventing it. Whatever the reason, people can see the result for themselves. They see the victim carrying the wound, the offender receiving the explanation, and the institutions asking everyone to stay calm after protection has already failed. At that point, it does not feel like justice anymore. It feels like Europe managing public anger after failing the people who needed protection first.